So what I'll do is I'll upload these documents to the group. This is the tender. Let's look at the first of all. We'll look at the bill that the Hayes County sent him.
So that went through quite quickly, didn't it?
Yeah, it was like within a couple days. This is what he sent them, but I'm looking for what they sent him. Yeah, this is what they sent him. Whoops. Okay. Okay, well, I'm going to have to redact this thing again, so bear with me here. There we go. I'm just
cleaning it up for him.
Sorry?
Just taking out the parts you don't want us to.
Yeah, I got to redact it so that Okay. Okay, now so this is what the court sent him. There we go. So standard letter, although they charge a lot of money for this record, and I can't tell you how many times I've had cases that just died because I didn't have the $5,000 to pay the fucking for the court clerk's record. So now I know how to do it. But anyways, so this is what, and I'll upload this to the group. Let's see here. I gotta put this up on. There we go. This is what's up on YouTube now. So this is the invoice that the clerk sent, $1,962 for them to, that's a money-making business, let me tell you. That's the letter from the clerk saying they wanted $1,962. And so then this is the letter he sent back. And I'll put this there we go. Whoops, that's not it. There it is. Okay, so this is the letter he sent back to them with the 1,962 grains of uncooked long grain white rice. I'm the affiant.
What did he send it in? Did he send it in an open envelope?
No, it was in a container. As a matter of fact, he told me they could keep the change. he put in more than the necessary amount and told him to keep the change. Anyways, so this is his name, upper and lower case, as a man, and beneficiary and equitable title holder for the Sestakay Trust, a living man, fresh in bud, being a lawful age, sound mind, do affirm and swear on the penalty of perjury the following. I'm the affiant in this matter with personal knowledge of the facts stated herein. I'm competent to testify. On September, whenever, I tendered 1,962 grains of uncooked long grain white rice as full complete payment for the alleged $1,962 invoice for the clerk's record in Hayes County, case number. This tender is made in good faith as lawful specie equivalent dollar for dollar under House Joint Resolution 192, June 5th, 1933, codified at 31 U.S.C. 5118, which suspends the gold standard and allows discharge of obligations in any lawful medium. So you could do that with anything, filing fees, anything. Hayes County has not specified the required specie for payment in violation of HJR 192 of the Texas Constitution, Article 1, Section 17, and the Uniform Commercial Code, Section 3-603. Rice, as a commodity of intrinsic value, serves as an equitable tender historically recognized in commercial law. This tender discharges the debt in full, and refusal constitutes dishonor under UCC 3-505. Waiving the claim, the underlying plea deal in case number, there's a long story with this, but was accepted on August 1st and rescinded on August 4th, rendering obligations null. A related Tarrant County case was dismissed, further extinguishing any basis for this payment. I declare a penalty of perjury the foregoing is true and correct. And then that's the notarized statement. So that's what he sent them, along with the rice. And then what they sent him afterwards was from the Court of Appeals. And that's this. Hold it. Let's make sure. Nope, it's not this. There it is right there. Okay, so this is what the Court of Appeals sent him.
How many days later?
Sorry?
How many days later?
Well, let me put it, it's like less than a week for the whole thing to happen. On Friday, October 3rd, that's today, the clerk's record, the 1-volume clerk's record, was filed in this court. That's it. That's all it says. But it got filed. So his 1,962 grains of rice satisfied the requirement to pay.
So how did he come to the conclusion to do that?
Well, he was over a barrel. I mean, he didn't have the money. He's got Smart Lab, but Smart Lab is down, and they're not sending any money out right now. They went and they're kind of locked up for a few days. They needed to move their website to a new host, and so they're down for like 4 days, and they're still down for another couple days yet. And then they're making everybody do KYC. You know what KYC is, Lori?
Clarify for us, please.
It's called Know Your Customer.
I call it facial ID, but...
Yeah, it's none of your damn business. Unless you have evidence that I'm involved in some criminal activity or something, mind your own damn business. But anyways, that's one of the things we have to deal with. And so they're doing KYC. And so fortunately, I've got a Mexican driver's license, so I was going to use that. But the bottom line, though, is that they want to have a driver's license, a government-issued ID, and all of that stuff if you want to continue getting money out of Smart Lab. They don't need necessarily they just want a government issued ID is what they want. And a picture of you next to your ID so they know that you're not dead. That's as it's a picture of life or something like that they call it. I don't know. But anyways, so so they want to do, so Smart Lab is doing the KYC. They're moving the website to a new location, and there's a bunch of changes happening, and so we'll see what happens with all of that. But and then exceedingly went down, and that's another long story. But so the things were going pretty good there for a while, and now they're not. But something else will come along. That's what my attitude is. I can tell you that when I got arrested, I just had this feeling that this is going to be the best thing that ever happened. And so far, it's working out that way. And matter of fact, we're getting ready to send a declaration of peace. See, technically, you have to understand that the Civil War didn't end. Okay, all there was a ceasefire. Okay, there was no treaty of peace, and so there was a ceasefire. Is all there was. So technically, the war still is happening. And so Texas, as part of the Confederacy, is still at war with the U.S., but the U.S. installed a military government here called the state of Texas. And so that's why, as the Republic of Texas, we need to send a declaration of peace to the president, to Donald Trump. And I think that he's going to be glad to see it because they need to bring the Civil War to an end. There's no way to bring it to an end at this point because everybody's dead. And so if they can bring it to an end somehow, like as in with we bring the Republic of Texas out of abeyance, then I think that they're going to be very happy about that because they can bring it to end, at least for Texas. The rest of the states, the southern states, really have to do that too. But so technically, the state of war still exists between the Confederacy and the U.S. That's why they have to have these, the war on terror, the war on drugs, the war on this, the war on that. 'Cause everything's about warfare. So anyways, so this is how you can do it. I can't send you the Word file because then you can figure out who, but what I can do is I can upload the files redacted that he made. And then you can get the text out of it and make your own. Of course, that's if you're in the US.
Oh shit.
Sorry?
No, yeah, there's backslash there. No social insurance number without dashes, nothing like that.
Oh, no. Well, they don't want social insurance numbers here in the U.S. anyways.
Social security, I mean.
Yeah, well, they want a social security number. That's true.
For all the set-offs that I've heard about, part of doing that is to claim your social security with no dashes.
Yeah, there's a lot of whoa, I got that in the wrong place. I got to put it in.
There's a lot of ways to skin a cat.
Yeah, there is. And I don't normally I don't follow any of that stuff because I like to stay in the real world. But it's good to know about it if you have to. And that's why, when they give you something to sign and you're in jail, you have to treat it like you're in prison or I should say, you have to treat it like anything they give you in jail is a contract. And so you have to treat it that way, that they want you to be in a contract. And so then what you do is you sign it with, I just put without prejudice. Matter of fact, what a friend that I consider to be pretty smart said is you should always also put without recourse. And so that's in the future. What I'm going to do is I'm going to put without prejudice and without recourse. I'm just looking for this document that he uploaded so I can upload it to the group.
And also my favorite is if they present you with any type of dollar amount, is to just question them to define their currency. So
Yes.
that you can pay them in wild rice.
Well, and that's what he did. This guy did. He was over a barrel. His appeal. We were suggesting that maybe he'd want to bring a war crimes complaint and bring it in federal court and bring up all these issues. But so it turned out that that they accepted it. So he's off and running. But there we go. Okay, so that's the tender. The first one is the letter they sent to him. The second one is the letter he sent to them. And then the third one is the letter from the Court of Appeals.
And when is it expected to be heard?
Oh, it'll be months. It'll be a long time. Nothing happens quick. But he's actually using grok and trying to increase his chance of winning. He hasn't filed his appeal brief yet. He's been messing with his appeal brief to figure out how to give it a better chance to win. You know what I mean? And so he's been doing things like that. There we go. What's this? I'm just looking in here, trying to upload this file. Oh, there we go. Okay, so this is the letter. The last one is the letter from the Court of Appeals telling them that the record got filed. So so that is how you can do it. Okay, and you can take that letter, the text of the letter that he sent, and put it into a Word file, and you're off and running. You can do that with just about anything. So you don't need to, should never pay for anything. Matter of fact, yeah, you can deal with any kind of government bill with that.
I beg to differ.
Sorry?
Well, I have to beg to differ because the time and energy that he spent on creating that document was not, he values his time, correct?
Well, it saved him $1,900, so he spent probably a couple hours on it, and so that's worth it. But some of them, it's not worth it. You're right. You have to decide how much time you want to spend on it and how much you want to fight that battle. I know that when I went in the federal court for the filing fee, I just told them, sure, no problem. Well, they sent me that interrogatory to fill out. An interrogatory is a questionnaire, right? And it's the impecuniosity interrogatory is what it is. Okay, so most people don't call that an interrogatory. They call it a application or something like that, but it's an interrogatory. They're asking for personal information on there. They're asking you to give evidence against yourself. And so what I did was I said, I'm sure, no problem. I'll fill out your document, your interrogatory. I called it an interrogatory. When you give me your statutory and delegated authority that requires me to fill it out, and a Fourth Amendment warrant telling me exactly what information I have to put in there. Crickets. Never heard another word about it.
Yeah, great approach. That's a good approach.
So anyways, yeah, never heard another word about it. Because the Fourth Amendment says that they have to specifically say what they're searching for, right? So they just can't say that you need to disclose all this stuff. You got to tell me what I have to disclose. And so, and signed by a judge acting in his official capacity. Wrong. Ain't no such thing. Not signing that, it won't be in his official capacity. So anyways, those are the things that you got to bring up, and it's the same thing when I was in jail in here in Fort Worth. I went and filed a motion to suppress the hearsay evidence because they had social security number and date of birth and name and all that's hearsay. And I said, I didn't disclose that information. And they did an illegal search of the government database to pull up that information. And that's an illegal search. They didn't have a warrant to search for that information, and I want it suppressed. And I neither admit nor deny the validity of any of that information, but it's hearsay, and I didn't admit it, and therefore it's inadmissible, and I want it suppressed. And so I did a motion to suppress the hearsay evidence. I also did a motion for an identity hearing. We talked about that last week. And I went and I think I uploaded those files to the group. And so we got established that I'm not lost at sea. I'm a man and I'm on the land and I'm not lost at sea. And so that causes a major problem because if I'm a man on the land, then I get common law. And none of that stuff they were doing was common law. And so that's why they dismissed the case. And then I told them that I have diplomatic immunity because I'm a senator with the Republic of Texas and I was previously a charge d'affaires. And I mean, you just nail them with one thing after the next. And, they just don't want to touch that thing with a 10-foot pole. Now we're going to go to the President of the United States and we're going to bring some heat down on them from heights they can't possibly imagine, because I think that Trump would love to get this kind of information because he'll break this off in their ass. Anyways, we'll see. That's all I can say. I can't guarantee anything. I don't know what Trump's going to do. I'm just hoping he will. You know what I mean? So that's what we're doing right now is a declaration of peace. And I don't know that I want to go through that right now, but we can go through my petition for writ of certiorari if you'd like. Do you want to go through the I've got that petition for writ of certiorari. I've been tweaking it a little bit, and I've got a appendix that I'm working on right now. And we'll do the petition for writ of certiorari that I'm going to file with the Supreme Court. And I was looking at the rules, and so I've made some corrections because of the rules. And so why don't we do that? We'll start going through that petition for writ of certiorari.
Okay, then you'll bring the peace document next week. Will you have filed it by then?
What I'd like to do with that is once we get it filed, then we'll go through it, okay? Because right now it's something that we're talking about in the Republic of Texas, and there's probably going to be some changes to it. And so once we get it filed, because then technically, and when I say filed, I meant sent by registered mail to the president, okay? So once it gets
How many
filed,
of you are in on it?
well, right now it's the president, it's the executive branch in the Republic of Texas. So you're talking the president, the vice president, the secretary of state, and the speaker of the House of Representatives. The vice president is the president of the Senate, and I'm a senator. And so the president told me to go ahead and prepare it. And so I'm on edition number 5 right now. I've made several, and I sent them to them, and they look it over, but it's not the final edition yet, although we're getting close. Okay, we're getting close. And so, but it'll be signed by the president, the vice president. I'm thinking, okay, I'm putting signatures there for the secretary of state, the vice president, the president, and the speaker of the House of Representatives. Now, I don't know if they're all going to sign it. They're going to have to decide it because I'm just a lowly senator. And that's the executive branch, and it's the executive branch that deals with treaties. And so, I think that I kind of pitched it to them, and I think they like the idea, and I think that Trump is going to be very interested too, because once you read this thing, you'll see that it's very compelling. Why we need to have a peace treaty with the United States, why the Republic of Texas needs to be at peace with the United States, and why it could be huge. It will be huge, and we might get a settlement because of it. And that's really what I'm working towards, because they've engaged in war crimes, and I'm telling them that you've engaged in war crimes on numerous occasions against people of the Republic of Texas, and we don't want to be at war. And so we've been damaged, and we need some compensation. But we're willing to, make us an offer. We're not going to. We'll waive all tort claims. Make us an offer. We don't want to be unreasonable. Make us an offer, and so we can settle the matter. But we've been damaged, and anyway, so we'll see what happens. But that's why I don't want to talk about it too much, because there's a lot of things that could change in it, and there could be a settlement, and it might be that we can't talk about the settlement too. They like to keep that stuff, confidential. Anyways.
Okay, but I'm going to ask next week.
Sorry?
Okay, but I'm going to ask next week.
Go ahead. I can't say for sure that we'll have it ready next week, but once we have it in the mail, then I think that, because all treaties are public, and so it'll be essentially public once we've decided on what we're going to send them. And so, I think we'll be able to talk about it at that point. So this is my petition for writ of certiorari to the U.S. Supreme Court. So this is the table of contents. Word is a pretty slick program. They say in the rules to use certain fonts, and so that's why I had to make a bunch of changes and use different fonts, and they wanted it double spaced. So some of it's double spaced, some of it's space and a half, and I used this font that they wanted. Just because I don't want them having any excuse to send it back. Costs a lot of money to send that. You got to make 40 copies and send it back and forth and all sorts of stuff. That gets expensive. Anyways, so this is my petition for writ of certiorari. So the petitioner converted silver to land on the land of Texas in 2021 and stated on the face of the deed that the petitioner failed to be a U.S. citizen or Sesticate Trust, true copy of which is attached hereto in the appendix, all of which is incorporated herein by reference in its entirety. The Pope's County of Montague Ecclesiastical Municipal Corporation, under the direction of the Pope's Texas Controller and in conspiracy of the Pope's private bar guild, rendered by force the petitioner's land, thereby converting the petitioner's land from the land of Texas to the Pope's owned and operated foreign district of Columbia under the Commerce Clause. The Pope's County of Montague Ecclesiastical Municipal Corporation proceeded to enslave the petitioner with their Vatican minor estate, with their tax notices, tax liens, and threat letters. The petitioner served a registered mail on Catherine Phillips, a Catherine Phillips notice and demand to the ringleaders of the Pope's ecclesiastical, and I think I'll make some small changes here. I don't want to be too derogatory. To the leaders of the Pope's Ecclesiastical Municipal Corporation, explaining they were engaged in multiple felonies and that the petitioner failed to be a U.S. citizen or a Sesticate Trust, and demanding they produce a bona fide contract, true copy of which is attached hereto in the appendix, all of which is incorporated herein by reference in its entirety. The Pope's County of Montague Ecclesiastical Municipal Corporation got the Pope's private bar guild members to file a tax suit in the Pope's 97th District Court before the Pope's bought and paid for clergy, Patricia Coleman Byers. The petitioner filed 78 criminal complaints into the case and sent them to the Pope's Federal Bureau of Investigation, and the Pope's United States Attorney and the weaponized Department of Justice ignored them, as well as Byers. The Pope's bought and paid for clerks masquerading as judges, clergy on the Pope's 97th District Court issued a bill of pains and penalties similar to a bill of attainder with their legislative act against the petitioner named individual, and assaulted the petitioner with the Pope's minor estate to justify the theft of the petitioner's land by the Pope's County of Montague and their private bar guild handlers. I got to thin this down here.
Abbreviate it. Or put it in your gloss. That's how it's going to be known.
Sorry?
You could just abbreviate that, put it in your glossary or the index that you're abbreviating that to be abbreviated.
I just don't want to mention the Pope so much. And right now I got him like every other word. It's kind of, yeah. But it's the County of Montague Ecclesiastical Municipal Corporation. It is an ecclesiastical, but I don't want to mention it too much. I do want to mention it under the direction of the Pope's Texas Controller and conspiracy. So maybe I'll take that out. In conspiracy, the Pope's private bar guild rendered by force the petitioner's land, thereby converting the petitioner's land from the land of Texas to the Pope's owned and operated foreign district of Columbia under the Commerce Clause. I think I'll leave that. Proceeded to enslave the petitioner with their Vatican minor estate, their tax notices, tax liens, and threat letters. to the leaders of the ecclesiastical municipal corporation, explaining that they are engaged in multiple felonies, that the petitioner failed to be a U.S. citizen, Sesticate Trust, demanding they produce a bona fide contract, true copy of which is attached here to, all of which is incorporated herein. The County of Montague Ecclesiastical Municipal Corporation got the Pope's private bar guild members to file a tax suit in the Pope's 97th District Court. So we'll go in the 97th District Court before the Pope's bought and paid for clergy. Petitioner filed 78 criminal complaints into the case, sent them to the Pope's. And we'll just take that all out of there. To the Federal Bureau and the United States Attorney, and the weaponized Department of Justice ignored them as well as buyers. In the Pope's 97th District Court, issued a bill of pains and penalties, similar to a bill of attainder with their legislative act against the petitioner. The named individual assaulted the petitioner with the Pope's minor estate to justify the theft of the petitioner's land by the County of Montague and their private bar guild handlers, and enslaved the petitioner for their Vatican Jesuit handlers. And they were in the process of selling the petitioner's land when, on the day of the petitioner set off their extortion with their Federal Reserve note commercial paper fake money that are only for use in the Pope's foreign-owned and operated District of Columbia. Petitioners never in his life breached the peace, but the Pope's Federal Bureau of Investigation and military police refused to investigate the felonies, and the Pope's United States Attorney refused to prosecute the felonies that the Pope's County of Montague Ecclesiastical Municipal Corporation and conspiracy with the Pope's private bar guild members had engaged in support of their weaponized Department of Justice and their communist handlers. Petitioner filed bar grievances against 98 of the Pope's private bar guild, some more than once. They were all dismissed as an inquiry. The petitioner appealed all the dismissals to the Pope's Board of Disciplinary Appeals, and they got dismissed again. All of this originated with the Pope's Ecclesiastical Municipal Corporation established by Congress, which is now owned and operated by the Pope. So it's kind of saying that too many times. So it's originated with the Ecclesiastical Municipal Corporation established by Congress that is now owned and operated by the Pope. Petitioner filed a lawsuit in Fort Worth Federal Court, and they issued a findings, conclusions, and recommendations of the United States Magistrate Judge, which fails to be the required findings of fact and conclusions of law, which means it has nothing to do with facts or law, which means they're legislating from the bench, and it's a bill of pains and penalties, similar to a bill of attainder, and unconstitutional under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. True copy of which is attached here to in the appendix. Petitioner filed document 104, notice of objection to the magistrate judge's findings, conclusions, and recommendations, and motion to reconsider on 15th of February 2025, a true copy of which is attached here to in the appendix. Court filed an order accepting findings, conclusions, and recommendations of the United States Magistrate Judge, filed 21st of February 2025. True copy of which is attached here to in the appendix. Court filed a final judgment, filed 21st of February 2025, a true copy which is attached here to in the appendix. Petitioner filed a notice of appeal, and it's in the Court of Appeals for the Fifth Circuit, case 25-10360, a true copy of which is attached hereto in the appendix. Petitioner filed document 108, notice of constitutional challenge, filed 10th of March 2025, a true copy of which is attached hereto in the appendix. Petitioner filed document 112, mandatory judicial notice of 12 presumptions, certified copy, filed true copy. Petitioner filed document 113, affidavit of life, certified copy, filed May 30th of May 2025, a true copy of which is attached hereto in the appendix. Petitioner filed document 114, a notice of void judgment, 30th of May 2025, a true copy of which is attached hereto in the appendix. So those will all be in the appendix. So there'll be an appendix. Statement of jurisdiction, that's a separate document. And there has to be a table of contents for the appendix. But the pages in the appendix don't count as far as the number of pages in this petition for the writ of certiorari. And right now it's 46 pages, so I got to thin it down a little bit. It needs to be less than 40 pages. Article 1, Section 1 of this Constitution for the United States of America says all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. And Article 1, Section 8, Clause 9 says to constitute tribunals inferior to the Supreme Court. And since this court was created by the Judiciary Act at 1 Stat 77, the one Supreme Court talked about in Article 1, Section 8, Clause 9 and Article 3 can only be talking about a common law court that existed prior to the Constitution, because this court is a legislative inferior court created under Article 1, Section 8, Clause 9. This petition for writ of certiorari is brought pursuant to Article 3 of the Constitution for the United States of America that provides judicial power of the United States shall be vested in one Supreme Court, and such inferior courts as Congress may from time to time ordain and establish. It's Article 3, Section 1. This petition is brought as emergency petition pursuant to Rule 11. This action should be a petition for writ of error, but your clerks insist on assaulting the petitioner with the Pope's District of Columbia Codes, Rules, and Regulations under color of law, which is objected to on and for the record. This action is brought in the lower courts because of an act of the United States Congress, because taxation of land originated with an act of Congress acting under executive authority 3 months after Lincoln ordered Congress to reconvene with Executive Order Number 1 on 15th of April, 1861, at Chapter 45, approved August 5th, 1861, at 12 Stat 292. Which has not been repealed or modified, and that provided for tax assessors and collectors at 12 Stat 296, required to execute a bond at 12 Stat 296, have an oath of office, 12 Stat 297, Secretary of the Treasury to provide regulations, 12 Stat 297, direct tax on lands and lots of ground, 12 Stat 297, Board of Assessors, 12 Stat 300, tax liens, 12 Stat 303, it goes down. Anyways, this is an emergency petition because this has national importance due to the fact that almost every city, town, county, state of the union are now operating the Pope's ecclesiastical municipal corporations and assaulting almost all of the people, if not all of the people in this country, with the Pope's unconstitutional minor estate. And the Pope's private bar guild, which is all of which is evidenced by the weaponized courts that Trump is trying to get rid of, and his weaponized Asian working group in the Department of Justice. Constitutional and statutory issues involved. Okay, so these are all required sections. And so if you go up here in the table of contents, see, here's the table of contents. And see, here's the required sections. Summary of the case, statement of jurisdiction, constitutional and statutory issues involved, and statement of the case. And so, and then that's all this. And conclusion. So that's all required. That's in the rules. The rules require that stuff. Okay, so statement of the case. Constitutional statutory issues involved. The 1871 Ecclesiastical Municipal Corporation created by Congress at 16 Stat 419 is an unconstitutional violation of Article 1 and Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because it is a law respecting the Pope and the Vatican and the Holy See, and also because they're busy subjecting the petitioner to the satanic religious ceremony with their fraud, deception, lies, idolatry, necromancy, and violation of the petitioner's sincerely held Christian religious beliefs. The minor estate, 31 3 CFR 363.6, is unconstitutional because it is created by the Pope in violation of Article 1 and Amendment. National Bar Foundation and all of their subsidiaries are all unconstitutional violations of Article 1 and Amendment because their head office is located in the Pope's owned and operated ecclesiastical city-state called the City of London, which means it's owned and operated by the Pope. The judgment of the 97th District Court, as well as the judgment of the Northern District of Texas, are each a bill of pains and penalties, which are prohibited under U.S. Constitutional Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. They're bringing District of Columbia outside a maximum 10 miles square in violation of Article 1, Section 8, Clause 17. They're giving aid and comfort to the enemy in a time of war in violation of Article 3, Section 3, Clause 1. Statement of the case. The petitioner is posterity. The petitioner's mother and father were joined in the state of holy matrimony at the time petitioner was born to them, and all of his ancestors were joined in the state of holy matrimony as evidenced by the statement of original status in the affidavit of corporate denial, which is recorded with the Pinellas County Recorder at fee number 2013 032373, and the pedigree charts that are attached thereto. They are now the unrebutted truth and public policy, which may be viewed at their website. And Will Livingston ratified this Constitution for the United States of America on behalf of New Jersey, 1787, is the appellant's fourth great uncle, which means that the petitioner is posterity as found in the preamble. Let's change that. Is the petitioner's fourth great uncle. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. To ordain and establish this Constitution. And the petitioner is entitled to right of blood. And right of blood cannot destroy any civil law, because all the laws of Congress after 1871 and all the laws of Texas after the Civil War are civil laws. The right of blood and kindred cannot be destroyed by any civil law. That's Maxims of Law, Bouvier's Law Dictionary, 1856 edition, page 768. And this court is operating under power which is derived from the petitioner as posterity, and the maxim says that power which is derived cannot be greater than that from which it is derived. And that's Bouvier's Law Dictionary, 1856 edition. Therefore, it's impossible for the petitioner to give the Pope's County of Montague or their private bar guild handlers or this court any authority over the petitioner, and the Legislative Inferior Supreme Court of the United States agreed and said it's impossible to confer a sovereignty which will extend over the petitioner. And this is McCullough versus Maryland. The sovereignty of a state extends to everything which exists by its authority or is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. The petitioner is exempt from the Pope's County of Montague and the Pope's private bar guild, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And that's U.S. Supreme Court, Kawanakoa versus Polyblank. And the petitioner requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States. which is the supreme law of the land. Anything in the constitutional laws of any state to the contrary notwithstanding. Article 6, Clause 2. And we the people fail to be U.S. citizens because the Pope's 14th Amendment U.S. citizen failed to exist when the Constitution was written. So this kind of goes along here. We're on page 10. We got 30 more pages. Do we really want to go through all of this?
Maybe somebody has some questions.
Yeah, well, if anybody has questions. Matter of fact, I was recently, and I have to, well, it's really not something that's a topic of that case of our Declaration of Peace. But there was recently a case that I came across that was a Texas case that said that, first of all, did you know that Texas was brought into the Union under the Articles of Confederation? A lot of people don't know that. And that is like very, very important. So what they say is that when the Constitution, sorry? Somebody have something to say? So
I think somebody's mic just opened up.
Okay. So anyways, yeah, that's in the, there's a couple House Joint Resolutions that talk about it. Matter of fact, that's the basis of our, of the Republic of Texas, that we brought it out of abeyance. Matter of fact, maybe I'll just show you some of that. Where is it?
A snippet.
Yeah, a snippet of the Declaration of Peace. This is the Declaration of Peace. Let's go up to the very beginning, though. So, the state of Texas was part of the Confederate States of America, and a technical state of war still exists between the United States and the Confederate States of America because there's been no treaty of peace. Whereas the state of Texas is a military government put in place by the United States Army under Article 1, General Orders 100, the Lieber Code. And this is Article 1. It says a place, district, or company occupied by an enemy stands in consequence of the occupation under the martial law of the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of a hostile army proclaims its martial law. Whereas the martial law continues to this day under Article 2, General Orders 100, Lieber Code. Martial law does not cease during the hostile occupation except by special proclamation ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war, when the occupation of a place or territory continues beyond the conclusion of peace is one of the conditions of the same. Because there's been no special proclamations by the Commander-in-Chief, which is the President of the United States, and there is no treaty of peace to this date. Whereas President Andrew Jackson officially recognized the Republic of Texas on March 3rd, 1837, which is also recognized by France, December 25th, 1839, and other nations, including Belgium and the United Kingdom. Whereas, and this is taken from House Joint Resolution number 1, dated 29th of December, 1845. So, the territory properly included within and rightfully belonging to the Republic of Texas was erected into a new state called the State of Texas on an equal footing with the original states in all respects whatever, okay? When they're saying the original states, they're talking about under the Articles of Confederation. That's the original states, or the original 13 states. And under the Articles of Confederation and Perpetual Union, as found in Chapter 1, December 29th, 1845 at 9 Stat 1, so it says this is the Section 1 of the Act extending the laws of the United States over the state of Texas. And it says, be enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that all laws of the United States are hereby declared to extend to and over and to have full force and effect within the state of Texas, admitted at the present session of Congress into the Confederacy and the Union of the United States, right? Confederacy. That's in 1845. So they're talking about the Confederacy into the Articles of Confederation. They're not talking about the Southern Confederacy. And in HJR 1, dated 29th of December 1845 at 9 Stat 108, and that's where it talks about the territory, that the territory properly included within or rightfully belonged to the Republic of Texas might be erected into a state called the state of Texas. So think about it. What they're saying, think about it. They're saying that the Republic of Texas still exists, okay? Just not being used right now, which means it's in abeyance. And so that's what some people figured out back in the 90s, early 90s. They figured out that the Republic of Texas was still there. All they had to do is start to operate it. Whereas, sorry?
No. There was a proclamation on how to I'm getting feedback. There is a proclamation once that I can't talk. I'm getting a buzz back.
There, I mute myself, then you can talk.
Okay. President Johnson's Proclamation 179, a grant of amnesty and pardon with restoration of all right of property. Under Lincoln, it's in the Assembly Room under Arizona, the excerpt from Lincoln's book, when 10% of the voters, number of voters, as the voters in 1860 do the Proclamation 179, the seditionist state will be restored to the Republic. So if you get 10% of the voters, of the number of voters that were in the state of Texas in 1860, to do the Proclamation 179, grant of amnesty and pardon with restoration of all right of property, then the state of Texas would be properly restored as a republic. So if you go to the Assembly Room, the Arizona Assembly Room, Queen can get it. There's a book, it goes page 62 of a link, and it talks about that 10% of the voters. I did my Proclamation 179. The first part's a grant as a grant deed, which I styled as a constitution for me, and then the second half was a oath, but I called the oath a consent decree since I was never in rebellion. But anyway, and it was interesting how it went down when I had got the grant recorded, and then when I got the oath recorded or the consent decree recorded. So Proclamation 179 by President Johnson.
Actually, there's a matter of fact, maybe I'll upload it to the group. I'll see if I can find it. There's a non-ratification of the 14th Amendment written by this Judge A.H. Ella to the Utah Supreme Court, and he says in there's been no special proclamations. There has to be a special proclamation ending the martial law.
Okay, I'm just quoting what Lincoln had and what President Johnson did. So,
well, I'm telling you that this judge in non-ratification of the 14th Amendment said that there's been no proclamations. So
and had any to have judges in 1759.
In other words, it's impossible to do.
Well, it has to come from the president. It can't come from someone else, and it has to be a special proclamation. Oh, there we go. Okay, that's right here. That's actually a pretty easy read. It's double spaced, but it goes through. This is a non-ratification of the 14th Amendment by Judge A.H. Ella to the Utah Supreme Court. in a case called Diet versus Turner. So I would suggest you read through that because there's some really, really good stuff in there. I got that a long time ago. And so it's definitely, it's 150 pages, but it's double spaced. So it's a pretty quick read. Anyways, he says that there's been no special proclamations. It's got to be a certain kind of proclamation issued by the commander in chief. It's only the commander in chief. That's what the Libra Code says. So, maybe, I'm just going by what the Libra Code says and what this judge said. So,
and I tried to get that case because you brought that to my attention in 2018. I tried to get that through the law library, which is supposed to be public accessible, and they told me it was no longer required. Okay, so it's so valuable that they're burying it. And I've heard Smoking Baby, that's who brought that to your attention right now. Big Blue. He's brought that to our attention in the group many, many times because it never has been ratified. And that needs to be on everybody's foremost attention.
Well,
I'm glad he brought that up.
I think that they deliberately, they want the warfare, especially we have tyrants. I think Trump is trying to end the warfare. And I think that's one reason why he's going to do something about this declaration of peace. But the rest of them, they always wanted warfare. There's always a war of some sort. There was the war on crime, the war on drugs, the war on terror. There's war on this, war on that, war on everything else. And so they always wanted some sort of war because it promoted their agenda. And Trump is trying to end the warfare.
Yeah, and Smoking Baby did his, I think he was mentioning, because he wanted to show that he was non-combative and not part of the war as well. So that's why he did it.
So, and there's nothing stopping you from doing it yourself. I actually did back in 2005 when I was doing the redemption process. I did a declaration of peace too, and it's recorded in Arizona, and so that's not a bad idea. I'm not saying don't do it.
You should have told him that.
But the bottom line though is that there's no general declaration of peace that applies to everybody unless it comes from the commander in chief. And so, anyways, at any rate, I uploaded that document so you guys can have it to reference. So what happened after the armistice? Whereas after the armistice of the war between the states, many years have passed by, and all those involved in both sides are now dead. And in the early 1990s, some of the people of Texas, after reviewing the Act of Congress 9 Stat 1 and the resolutions HJR 8 March 5th, 1845, 5 Stat 797, and HJR 1 29 December 1940, or no, that's 1845 too. Boy, it's a good thing we're catching that. 9 Stat 108 of the U.S. Congress and other historical evidence discovered that the Republic of Texas was in abeyance, okay, which means dormancy. It's just not being used, and brought the Republic of Texas out of abeyance and organized a provisional government of the Republic of Texas and held elections and have been holding elections ever since to peacefully provide common law remedies for the people of Texas, because the state of Texas is a military government operating exclusively under martial law. Whereas the Republic of Texas is a foreign government under 18 U.S.C. Section 11, irrespective of condition of recognition, irrespective of recognition. Because the first thing the state of Texas actors say to us is, "We do not recognize you," speaking of the Republic of Texas. Whereas the Republic of Texas is a group of men and women trying to peacefully bring common law remedies to the people of Texas, because the state of Texas is a military government operating exclusively under martial law. Whereas common law is the law of the land in America and was here long before the government was, and that's Hale versus Henkel, 201 U.S. 43, 1906. And the military government's required to step aside when we the people step forward. That's found in Ex parte Milligan, 71 U.S. 2, 1866. And common laws everywhere above the high water mark and after the first bridge on any navigable river, except for the District of Columbia on Article 1, Section 8, Clauses 17 and 18, and any federal enclaves as affirmed by Section 14 of the Northwest Ordinance, 1787, that was passed just 3 months prior to the U.S. Constitution being ratified, as well as affirmed by the Judiciary Act of 1789 at 1 Stat 73. Whereas in the year 1995, the Supreme Court of Texas dismissed a case involving the people of the Republic of Texas for lack of jurisdiction. Case number 95-1002, styled In Re, the People of the Republic of Texas, by and through Richard L. McLaren, their legal diplomatic representative as acting ambassador and consul general and legal affairs officer for the Territorial Land District of Tell. Whereas the state of Texas actors have repeatedly engaged in war crimes against the people of the Republic of Texas using the Pope's minor estate, 31 CFR 363.6, and the Pope's Roman canon law and the Commerce Clause, Article 1, Section 8, Clause 3, to bring the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. Just let me check something here. No. Okay. I need to change something here. There we go. Okay, so now the people on YouTube will be seeing it. Well, let's close that. And let's make this bigger. There. You guys ought to be able to see that better. Yeah, way better. And through their plenary power nationally covers those citizens even in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company versus Tidewater Transfer Company, U.S. Supreme Court, 1948. By imposing the District of Columbia plenary power dictatorship, martial law, and taking reprisals for political beliefs, taking reprisals for religious beliefs, subjecting the people of the Republic of Texas to their satanic religious ceremony for their Vatican handlers under Roman law and canon law, failing to provide a fair and regular trial by jury as required by the supreme law of the land, Article 6, Clause 2, but instead subjecting us to their inquisitions for their Vatican handlers. An inquisition is one way of proceeding in ecclesiastical courts. And selling us into slavery. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. Denying us the right to pursue happiness, coercing information from us and from third parties, coercing plea bargains, illegal search and seizures, denials of due process of law, fake warrants recently in conspiracy with the New Mexico State Police, false arrests, false imprisonments, attempted murder, because we have the right to resist an unlawful arrest with lethal force if necessary, U.S. versus Schooner Amistad, U.S. Supreme Court, 1841, and other war crimes too numerous to count. And the Federal Bureau of Investigation has refused to investigate these crimes, and the U.S. Attorney has refused to prosecute them because we do not recognize you, speaking of the Republic of Texas, in support of their targetedjustice.com agenda, and the federal authorities are busy supporting the war crimes by helping state of Texas actors take reprisals for political beliefs. Whereas the War of Independence was fought over the imposition of martial law in what was then the colonies, as found in the Causes and Necessities for Taking Up Arms issued by the Continental Congress in the year 1775. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use and exercise of the law martial. And for altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us. And that's why we took up arms, folks. Whereas the President of the United States has a sole authority for international affairs, and Andrew Jackson previously gave official recognition to the Republic of Texas March 3rd, 1837. So, anyways, I'm not going to read any more of this, but this will give you an idea on where it's going. Right, right. Armistice means ceasefire, and a treaty of peace is required for the war to end. Yeah, somebody on YouTube is saying that, and they're 100% right. Got to have a treaty of peace. Otherwise, the war doesn't end. So, anyways, does anybody have any questions at all? I think we'll go to the questions now and start to wrap things up. I don't want to go completely through the whole thing because we haven't. It's some of that stuff that we just talked about is pretty well going to be the same, but there's so Texas came in under the Confederacy. You have to understand that. Okay, Texas was on an equal footing with the other original 13 states. That's why things are different in Texas than they are in the other state. And Texas, there's two kinds of states in America, and most people don't realize this. There's states that were the original states, and there's states that were originally territories and became states. Okay, that kind of state is different. Okay, than the original states, and it's completely different. And so you have two kinds of states. There's states that started out as a territory, and there's states that started out as a state. And so the law treats them differently. And so there's differences. That's why Arizona, for example, is different than Texas, for sure. Now that can be better to have it Arizona. There are certain advantages actually because Arizona does have a treaty of peace, and but the treaty of peace doesn't say anything about ending the martial law. Once you understand that, though, the courts have a duty. There's the courts are different in Arizona, and so yeah, you have to understand that there's differences between the states because of how they came in and history. History is like big time important. Anyways, does anybody have any questions they want to ask? I think what I'll do is I will silence my microphone so then if somebody has something they want to say, they can do it without feedback.
Yeah, we appreciate that, Glenn. I sure appreciate you going through that. I know you didn't want to bring it up right now, but yeah, it does apply to a lot of the other documents, and you've covered the history like the pro you are. I see. So, but the gentleman that was on last night, I noticed has come to the mic, so I'm hoping that he's going to introduce himself to you. Hard to Kill, are you there? Actually, Ed, how are you doing, Ed? Maybe he's unable to speak at the moment, but he was the gentleman that was here last night mentioning some of the things that you had brought up. JW brought it up just before you were speaking. And, but I'll let anybody else ask any questions if they have any. Hard to Kill, GA, are you there?
So, anyways, I think we'll wrap it up. The important thing to understand is that the Republic of Texas still exists. And I think that you could probably make the argument for probably every other state in the union that the de jure entity still exists. There's a municipal corporation, and it's kind of like an overlay. And so once we get it established that the Republic of Texas is this way, then I think it'll be easier for other states to do the same thing. So I think it'll be good for everybody to be able to do this. That's why I say if we can come to peace, that'll be good for the United States too, because right now they've got this war with the South, okay, and the whole southern states, that this war, this open warfare that's sitting there, and they can't make it go away. And if we can step forward, because I've heard there's actually people in North Carolina that want to do the same thing, and so once we do it, and once it works, then there's other states that were previously the Confederacy that want to do it too, and that will just be that'll just be a good thing for everybody. And then Trump can say that he brought an end to the Civil War, brought a conclusion to the Civil War. It's total peace, and then see, you got to understand. Remember, I told you about how that causes the necessities for taking up arms. It says to supersede the course of common law, instead to publish the use and exercise of the law martial. Martial law supersedes common law. So you got one or the other. You cannot have both. But you have two jurisdictions, and so that's why we need a declaration of peace. Because then even in the state of Texas, there'll be a peace, the martial law will end, and then they'll be able to recognize common law. Right now they can't. They can't do common law. They can't see common law. They can't, it's like oil and water. They can't mix. And that's why the Republic of Texas is so important, because we see common law. We're only common law. And so it's I really think that this is going to be, when this happened, I just had this feeling come over me that this is just going to be the best thing that ever happened, and it's working out that way even now. When they dismissed the charges, they dropped the case, they dismissed the case, they just and so they're hiding, they know they screwed up, and now they got a problem. And so now we get to, what we can do is with this declaration of peace, if we can get this in front of Trump and get Trump to basically recognize, because that's what we're going to ask him to do, is recognize the Republic of Texas, reaffirm the recognition that Andrew Jackson did with the Republic of Texas, and reaffirm, because what happens is when any country goes to war with another country, all the treaties go out the window, right? All the treaties get dissolved immediately, all of them. And so then after the war is over, they got to reaffirm the treaties. They got to decide. They'll go through. If you go to the U.S. Treaty Collection and you look at the Definitive Treaty of Peace of 1783, it'll say that there's only Article 1 is still being is still valid. The rest of it's not, and there's reasons for that. So, but you got to go through all the treaties and decide which ones you're going to reaffirm, and so you're not necessarily going to reaffirm all the treaties. You got to decide which ones. There's all sorts of stuff that you have to. So if we get, so then what'll happen? I'll tell you right now. Is if we get somebody from the State Department calling us up and wanting to reaffirm the treaties, the first thing we're going to be saying is, can we get a diplomatic passport? And so absolutely, that's going to be the, and so then it's going to be wonderful, and then who knows what'll happen. They'll be calling us up and saying, we'd really like to settle this matter. And hey, my attitude is, I'm not interested in money, although we need some compensation because we've been damaged, but money isn't the main objective here. The objective is peace, friendship, and communication. And so that's what we're going to be working towards. And if we can get that, then the money is really secondary. And so that's really what we want, is we want to have a peaceful, friendly relationship, and we want to have an opportunity to build trust. And so that's what our goal is. And so friendship is more important than money any day of the week. So that's why I said, as soon as this happened, I knew this was just going to be the most wonderful thing. And I still know it. It's just going to be absolutely wonderful. Anyways, we're still working on this Declaration of Peace. And so how this all plays out is yet to be seen. I have no idea what's going to happen. I have some hopes, but at the end of the day, no idea. It's just some hopes. But anyways, did somebody else want to say something?
Yeah, can you hear me?
Glenn. Yeah, I can. I'm sorry. I muted it somehow. I didn't mean to. Can you hear me okay?
I can. I'm muting myself so you don't get the echo.
Oh, okay. Well, Glenn, this is Ed from Georgia. You and I we do the New Year End bash at Daniel Joseph's thing for the guest speakers. That's the last time I talked to you. But before that, I understand we have a mutual friend in Texas named Lewis, and it's possible that you might know John as well. But anyway, some of the things that you said, you know what I found very interesting, Glenn? You said Declaration of Peace, but I heard you earlier talking about the 1783 Paris Peace Treaty and, some other treaties. Do you know there's no law preventing me from making a treaty with the United States?
Oh, that's true. Yeah, no doubt. Yeah, everybody can do that if you want.
And if treaty law is right up there with the common law, then I would vote for calling it a treaty of peace. And I've already got some ideas for that that you might be interested in.
Well, I'm open to ideas for text. We have someone else that we're going to work with also. So I'm open to any ideas.
I'd love to do a brainstorm with you guys. I'll be able to show you what I've got and why I've got it.
Okay.
We can use all those things you talked about. We got to go back and look at the treaties. You're absolutely right. But everything they've done after they put congressional districts in the states, they're free game. They're free game for us to say, hey, even though you're doing this, and that to me, I'm going to make a treaty of peace with you. And if you file it and they don't accept it, that tells you everything you need to know.
Yeah, but what we're doing is we're doing one for the Republic of Texas as the Republic of Texas, because the Republic of Texas technically is part of the Confederacy and technically is in a state of war with the United States. And we want to do a declaration of peace. We're calling it a unilateral declaration of peace because we want to be friends. Okay, we don't want to be an enemy. We don't want to be at war. And we don't think that it's good for them to be at war either. And Trump, I think, is going to be sympathetic to this. And so that's why we're doing it. We're doing it a certain way. We're doing it as the Republic of Texas. This is not me. Okay, this is not me. This is doing it as the Republic of Texas. I'm a senator with the Republic of Texas. And this will be signed by the president and the vice president and the Secretary of State and probably the Speaker of the House of Representatives. And so this will be signed by the government. If you go to 18 U.S.C. Section 11, the Republic of Texas is a foreign government. And so it'll be signed by the government of the Republic of Texas. And we're basically telling them that we're going to do a unilateral declaration of peace, and it's I thought about a treaty of peace, but we decided to do it as this, but it's not set in stone yet. It's not signed. We're still talking about it, and so we're open to any ideas you might have.
Yeah, mine's probably going to be a little different than what you would normally. And by the way, I love the way that you write your briefs. Let me just put that out there right away. I mean, I like how you hit them in the mouth with the truth. So I can certainly relate to that. So I think that what I want to do is I just want to give you my overall strategy on it, let you look at a mock-up of what it would look like. And then, if my strategy can intermingle with what you're doing, then by all means, I'm offering it for free.
Well, and that's why I say I'm open to ideas, but you have to understand that this is what we're trying to do as the Republic of Texas, because
I think
technically,
it's great. I think it's great. I meant to get a hold of you earlier because I got a Dunn's report for the judiciary of the state of Texas. Have you ever seen that?
yes, actually, there's a guy by the name of Daniel Shank that got it too, and Daniel Swank, and it shows that it's a for-profit corporation. It's a subsidiary of the state of Texas corporation. Yeah, I seen all of that.
What I was amazed about by that report and what I wanted to talk to you about is it appears to me from that report that the judiciary, the district courts of Texas, were incorporated 12 years before Texas became a state.
Well, they started in 1836, but I think the one that I saw was started in 1845, and
well, I've got the 1836 report.
Oh, that's interesting.
Yeah, I'm going to have to send that to you, and it came from a credible source. I can put you on the line with them. I think you may know some of the same people I do because I'm sure you reached out to several people. You know Lewis in Texas?
I know someone by the name of Lewis in Texas. Yeah, he's a tall guy, about 6 feet.
That's him. I think he's closer to 7, but yeah.
Well, yeah, he's probably 6.5. He's pretty tall. He's a big guy.
He's a big old boy.
He's a brilliant guy too.
What about John over there near DFW? You know him?
John. I don't know. I might. Doesn't ring a bell right now off the top of my head. Lewis lives in Keller.
That's right. And John lives about 45 minutes away from him. But I was in DFW a couple of weeks ago, and I met John there. Lewis couldn't meet me that day, but that was the closest I had gotten to you since I found out about you. But I told you back then when we did the special appearance calls that I watched your videos nonstop. I mean, if you got a burning desire for the law, they're great videos to watch.
Well, it's a networking thing. I mean, nobody knows everything, and so I just show what I have, and I can tell you that I've had judges tell me I know how to write a legal brief, but but my grandfather was a newspaper editorialist back in the 50s, and the 40s even. And so I guess it comes by blood. At any rate, there was 2 classes I hated in high school. One was English and the other one is history, and that's all I deal with now.
Well, at least you're smart enough to know that they weren't teaching you the truth in history class.
Well, it was boring.
I didn't like it too much either, come to think of it.
Well, it was, yeah, they can take something that can be quite interesting and make it really boring, that's for sure.
Yeah. Well, anyway, I just wanted to say hi to you. I haven't talked to you in over a year. And then I started finding out, you knew the same people that I did, or at least some of the same people I did in Texas. But I wish you all the success in the world. If Texas can do it, and Texas, in my mind, in my purview, has the best chance of seating from the federal municipal corporation, I think that Texas can do it because you're not landlocked. You've got ports, you got fields you can grow crops in. Basically, Texas is self-sustaining, in my opinion.
Yeah, if you're ever in Texas, maybe we can meet for lunch or something sometime.
We have to, buddy. I went to when I went a couple of weeks ago. I went to a place called Smokehouse Barbecue. You ever heard of that?
I love barbecue. I'll tell you, there's nothing better. Barbecue is to die for.
Yeah, well, I had to get it since I was in Texas.
Yeah.
But yeah, now, and another thing I want to talk to you about is I recently helped a group up in Utah and Colorado because I used to watch your videos about this subject matter all the time. But I watched it. They had a little problem in district court about who owned the land, the United States or them, and they had a land grant that went all the way back to 1899, and in 1936 they made their homesteads part of a national forest. So the sheriff would not mess with them. They would never mess with them. All of a sudden, the DNR game warden showed up and they started messing with them a little bit. The sheriff told them to leave them alone, that they had a legitimate claim, because it was all about that first in time, first in right thing, So anyway, I helped them with their legal issues. And the reason I was in DFW 2 weeks ago, because 3 weeks ago, or a week ago, I was in Utah, and they gave me a 1/4 acre for helping them. So, you got to tell me what my advantages are if I'm a free landholder.
Well, I can tell you that Utah has some really interesting stuff about the land, because I've seen land patents issued by the Attorney General for Utah, and they're better than a U.S. land patent. At least that's what I'm hearing from because of the Utah law and the treaties that they're involved with the federal government.
I would like to come to Texas and show you what it looks like. It's something to see.
We tried to help this guy in Chicago with sending him a Utah land patent, or actually hand carrying it, because the guy didn't want to trust the mail with it, and it didn't. The court wouldn't let him anywhere near it, because we think we could have got him if we could have showed that he's a landowner, and that's just because they only have things in court in jail. It's only things in jail. It's not people. And so what you have to do is you have to like what I did. I was recently in jail in Fort Worth here, and I did a motion for an identity hearing, and I did an affidavit of truth and said I'm a senator with the Republic of Texas, and I got involved with the Republic of Texas 2007, over almost 20 years ago. I was Speaker of the House of Representatives. And after that, I went to New York, and I was charge d'affaires. And so therefore I have diplomatic immunity as a charge d'affaires, because that's equivalent to an ambassador, an executive officer of a foreign government under 18 U.S.C. Section 11. Anyways, they dismissed all the charges. They had charged me with 3 felonies. There was a $500,000 bond. There was all sorts of bond restrictions if I did come up with a $500,000, and they just dropped everything like a hot potato. And I think
because they knew they were going to have about 45% of Texas coming after them if they didn't.
Yeah, they knew they had a problem, that's for sure. And so now we want to make it a slam dunk and get them crying uncle. You know what I mean?
Sure. So I want to tell you this before I let you go. I want to tell you how inspirational you are to people out there by telling you my own testimony. It'll only take me about 30 seconds. I watched you, and I read everything Ron Gibson ever wrote. And that was pretty much my, where, the tyranny in the land, you gotta own land to be an elector.
Yep.
You got to own land to do it. You got to own land to have rights, really.
Yeah.
According to law.
Absolutely.
So you're the one. You're the one that gave me the idea when I bought the spread that I live on right now. in Georgia, they require closing attorneys. You can't buy real property without closing attorneys. So I had 2 assigned to me. And I changed the purchase and sale agreement on the land to split the land up from the dwelling house, and I paid gold for the land. And for 12 days between the time the buyers and sellers signed the purchase and sale agreement until the day of closing, they called me. Those attorneys called me every day, giving me a reason why I couldn't use gold to buy the land. They weren't
Really?
Yeah, they'd say stuff like, "Well, it's not wire certified transferred funds, so we can't accept it." I said, "Well, that's the beauty of it, isn't it?" And they're like, "Well, what do you mean?" And I said, "Well, this is U.S. lawful money of account under 110.1. It's money wherever it sits, and come 12 days from now, it's going to be sitting on your closing table." I mean, the buyers and sellers have already agreed. You can't interfere with my contracts. Well, that doesn't mean we have to do the loan. I said, "What loan? I'm paying cash for the dwelling house." "Well, we'll call you back." And it was stuff like that. How do we? The next day they called me and said it's going to take me a little longer than 30 seconds. The next day they called me and told me and said, "Well, we have no way to verify the authenticity of the coin." I said, "Well, that's the beauty of it." I had to wait another 10 seconds. They said, "Well, what do you mean?" And I said, "Well, if I was stupid enough to give the sellers a fake coin of the United States, not only would that make me a felon, but they could also foreclose on my land and take the house with it. I assure you, it will be lawful money of the United States under 110.1.
No shit.
Yeah.
Secret Service hunts people down for counterfeiting, and they put them in jail for a hell of a long time.
I know. So, and I'm doing a closing, with attorneys.
Yeah.
So anyway, they thought of everything they could, and they said, "Well, we'll close the loan, but we're not going to touch the gold." And I'm like, "Well, wait a minute. I thought your primary job was to collect all the funds and give them out to the proper parties before the closing can be official."
Yeah, that's escrow.
I gave them hell, Glenn. You would have been proud of me. So anyway, I got it. I had to wait 90 days for my land deed. My land deed said tenant.
Really?
My warranty deed said tenant on it. So I found out something that may be of help to you. I told the group last night. My brother's an appraiser, and he went to a county nearby to work, and the county attorney was acting as the county acting as the county manager. So when he went to apply for the job, my brother asked him. He said, "Do I get any health benefits or any kind of benefits from the county?" He said, "Oh yeah, you get health care, and you'll get paid directly by the county, and you'll get a county vehicle." He said, "Well, that's great." And the county attorney said, "But you're not an employee."
Wow.
Think about it. Now,
Yeah.
if they send appraisers out that aren't county, so my cousin asked, he said, "Well, if I go out there in the county vehicle and plow somebody, what does that mean for me?" And he said, "Well, hopefully you won't get injured, but the county wouldn't be liable because you're not a county employee."
Right.
So, I told the group last night that it's my firm belief, Glenn, that 95% of our government, federal and state, are nothing more than private subcontractors. And the law says in Carter versus Carter Coal Inc., a 1950s case, it says that a state cannot employ private subcontractors and give them any governmental powers or authority. It's flatly unconstitutional. And there's a lot of state Supreme Courts that back that up too, including here in Georgia and over there in Texas. So here's the thing. The state licenses the appraisers. The state gives them the power and authority to walk on your land 24/7, 365 when they need to appraise something. That's governmental powers and authority.
Yep, sure is.
The reason I'm telling you this story, first of all, to say thank you for giving me the idea to tender the gold to begin with. And then the second reason I'm telling you is because if they're doing it here in Georgia, Glenn, they're probably doing it over in Texas too.
No doubt.
So why don't you look into it? See what you can find out.
I'll have to.
You know what I do? What I do is I send an APA request out and ask for their contracts between the Board of Appraisers and the Board of Commissioners, because they're a private entity as well, and then the Board of Appraisers and the county tax appraisers, or county tax office, and I ask them for their contracts between each of them. And if they don't send them, Glenn, because I sent an APA request, it's got teeth. And you can go to the State Office of Administrative Hearings at that point, get a number assigned for next to nothing to file a petition, and then use the subpoena power of that court to get those contracts. So there's ways you could work this over there. But if they're sending an appraiser on your land, in other words, if he's going down the road in his county vehicle and he slams into a car, he T-bones a car, and the county can't be held responsible. Well, what if he comes in on my private property and tears up my flower bed? Who would I sue?
Yeah, right.
So anyway, I wanted to tell you, though, I appreciate it. I would have never gotten that idea if I hadn't been listening to you and Ron Gibson, paralleling both of you. If I hadn't been listening to your videos with the Republic and reading Ron Gibson's work, I would have never even thought to do it. But it didn't cost me anything. I did it. They got the gold. Now the only question I got is, did the sellers own the land? That's the only question I got now.
Well, possession's 9/10 of the law, so you own it now.
Right. So Rourke, I don't know if you know who he is. He taught equity, and he's the one that taught me that when you tender gold and for an obligation for land, for real land, it passes both title and possession.
Really? What about silver? Same thing, right?
Same thing, as long as it's pre-1933. As long as the gold and silver is pre-1933, I don't care if you give them a $2.50 Indian head. You can make it worth any amount of Federal Reserve notes you want to, which is what I did. So anyway, I just wanted to tell you and the group, I think you're a great guy. I think you're a fighter. And ever since I've known you and ever since I've heard you speak, you've been one of my mentors, even though you don't know it. But I want you to know the kind of effect you have on people that actually listen to what you're saying.
Well, thank you very much.
Yes, sir.
It's a networking thing, and nobody knows everything, and I appreciate it, and I'm glad to help, and I get a lot of stuff from a lot of other people too. So,
I know.
So it's a networking thing, and that's why we'll win eventually, because there's more of us than there is of them.
That's right, buddy. Hey, listen, I'm the type that I have to live on my knees or live on my feet. I can't die on my knees. So, I'm going to be there to the end. I don't care what they do. John the Baptist was my favorite biblical character, because he said, "Go ahead and swing the axe. I'll be in heaven before my head hits the ground."
There you go.
I'm kind of like the John the Baptist of the South.
All right. Well, thank you very much, and yeah, definitely get in touch if you're in the DFW area, and I'm near DFW right now, and we'll meet for lunch or something.
Yes, sir. Happy to do it. Thank you, Glenn. It's good seeing you. Good talking to you again.
All right. No problem. Thank you for everything you do. It's a networking thing. No man is a mountain. We need each other.
Well, if you get it done in Texas, Georgia I would say would be the second best state to do it, because we got plenty of shoreline and plenty of fields for crops too. So, these states ceded into the Union. But I believe what happened was, when they did, they ceded the land to the United States. So that's what I'm working on right now. I believe every courthouse you have in the state of Texas, Glenn, and I know every courthouse in the state of Georgia, is sitting on federal land.
Oh, that's true.
Otherwise known as a federal enclave.
Yeah,
yeah, go ahead.
Well, there's actually the U.S. is buying them all up right now.
I know, but they own the land. So every case that happened in Texas and every case that happened in Georgia, in any state courthouse, was operating in mixed and multiple jurisdictions.
Right.
And you can't get remedy in mixed and multiple jurisdictions.
That's why we need the Republic of Texas.
And the Republic of Georgia.
That's right. Absolutely.
Ed, tell them what you said about Article 3 courts last night, please.
Say it again.
Could you tell Glenn what you said about Article 3 courts last night, that there used to be 200 and now there's virtually none?
Well, Article 3 judges. What I figured out is the elected judges, Glenn, are using these administrative hearings. And administrative hearings in the public law in 1946, the Administrative Procedure Act, it says that those hearings are in alignment with the Constitution, which to you and me means it's not the Constitution. And so, and I'm sure everybody else, but it has something called expedited process. These administrative hearings, like this paperwork you were just showing me in court, I guarantee you, sir, you were in an administrative hearing.
Oh, of course.
And so, in a crime, for a crime. So what they did, without people realizing it, is they replaced due process with expedited process.
Well, what it is that minor state. It's the Vatican. It's the Vatican. It's satanic. Everything is the Vatican, and yeah. so it's DC. And so, yeah, that's why we got to have the Republic of Texas and the Republic of North Carolina and the Republic of everywhere else too. But that's why Trump is going to want to do a treaty of peace, because I think he's a good guy. I think he's trying to end all this shit.
Well, I certainly hope so. I have my reservations, and it's probably just because of my age, but I wouldn't trust a politician as far as I could throw them. I don't care if they weren't a politician. If they were a banker before a politician, I really don't trust them. But you mentioned Andrew Jackson tonight. That's the most patriotic president I've ever studied in the history of the United States of America. He was trying to get rid of the banks.
I know. I think Trump is trying to do the same thing. He's got a picture of Andrew Jackson in the Oval Office.
I hope he does. I saw it. I hope he does. My old man taught me from early in life, only believe half of what you see and none of what you hear. So,
well, there's probably a lot of validity to that.
Yeah. But anyway, it's good talking to you again, and thank you for your presentation. I'm taking up everybody else's time. I don't know if anybody else has a question, but I appreciate it, Glenn. I'll talk to you soon.
Okay, you bet. And look me up when you come to Texas. And I think we'll just end it all, and we'll meet next week, same time, same place, same channel, unless anybody else has got anything.
Looks like we're all clear, but don't be late next week.
You bet. See you guys next week.
See you. Bye.
Bye. Yeah.